also to do with the Special Mining License 173, which is Noranda Jamaica bauxite, and to do with the environmental impact study that was commissioned, also with that, which would involve NEPA. So we had decided to defer that one until today's meeting. So we will have the ministry and NEPA appearing in front of the committee. So I'm sure that members had adequate time to read the report, which is, for me, in some senses, not a report. There's not quite much that was given to us in the report, but to say that the process still continues. But I'm sure that members also have questions to ask on how it is that we have reached to this process right now, seeing the whole area of the protection of the cockpit country and the way forward. So I'm sure that we'll have an informative meeting. And it doesn't really have to just stick to this, but also just generally the permits being given for bauxite mining in communities. My constituency, for one, is affected by mining of bauxite and permits that have been issued by NEPA itself in what they can do from what they can't do and some of the shortcomings. So we can generally look at the report itself and the TOR for the environmental impact assessment and can make some judgments from that. All right. So item 4, apologies for absence. All right. No apologies for absence. We're at item 5. Can you invite Member Sibley's? We'll be late. Okay, thank you. Can you invite in the ministry, the Permanent Secretary and her team, please? All right, until we can deal with the technical difficulties. Morning, Madam Pierce. Morning, Mr. Knight and the team. Madam Pierce, would you like to start out by introducing your team so that we can have it recorded? And if there are any opening statements, allow you to, and then we'll go into questions that members may have.
Okay, thank you very much, Chairman. Good morning again, and good morning to members of the committee. We are here before the committee, we meaning Ministry of Economic Growth and Job Creation and Ministry of Housing, Urban Renewal, Environment and Climate Change, along with NEPA, to respond to queries from the committee regarding the environmental permit that is being processed for Noranda, Jamaica Bauxite Partners Limited. And with me are, to my immediate right, Mr. Yannick Watson, Chief Technical Director, Ministry of Economic Growth and Job Creation, and to his right is Mr. Rollin Alvarango, Senior Director, Planning, Development Planning Policy and Monitoring Branch of the MEGJC. And from HUREC, Housing, Environment and Climate Change, is Ms. Gillian Guthrie, Chief Technical Director, under whose portfolio environment falls. And to my left is Mr. Peter Knight, Chief Executive Officer of NEPA, and he will introduce his team before I speak further. Mr. Knight.
Thank you very much, Pierce. Morning, Chairman, morning, members. I have supporting me this morning Mr. Anthony McKenzie, who is the Director of Environmental Management and Conservation, Mr. Richard Nelson, who is the Senior Manager, Environmental Management Subdivision, and Ms. Monique Curtis, who is our Manager, Ecosystems Management Branch. Thank you.
Just continuing that, we have been asked to come and respond to some questions. I just want to put it to the committee, and you would have seen in the brief that was sent that the process of awarding the environmental permit is ongoing. No decision has been taken, and we are now at the stage, well, NEPA, of getting feedback and comments, because the process includes consultations with external agencies, NGOs, other government entities, citizens, etc., etc. So that's where they are at now, and no decision has been taken by the NRCA, TCPA in that regard, but we avail ourselves to respond to any query that the committee may have at this time.
Thank you. Thank you, Madam Pierce. Members, are there any questions that?
Morning, Pierce. Good morning to the team. In going through the reports and looking at all the reports, I never got any closer to understanding why this has been stalled. I would like to rely on the technical experts and their recommendations. So if I could hear from Mr. Knight in particular, what his views are in terms of the license, and perhaps why you feel this has been stalling, and why it is that you feel, and where you think you may come down ultimately.
Thank you, member. Firstly, let me respond to say the process is not stalled. We are acting on the policy decision of the cabinet that all requests for mining in any area, whether it's in that particular area or it's going to be down in the Gisco region, that they must be subjected to an environmental impact assessment. So that is the process. So when Noranda and its consultants approached us, we outlined what is the policy direction that the area must benefit from an environmental impact assessment. We would have had discussions with Noranda, the consultants, and key government agencies, Forestry Department, the NWA, National Works Agency, the Water Resources Authority, and the Jamaica National Heritage Trust to build the terms of reference which we have made available to you all. Because the instructions are that we are to work together as a team, whole of government, so we didn't want to build a terms of reference, issue it to the consultants and Noranda. And one government agency was not satisfied with what was included. So the process opened in 2018, and we are at the point now where we have gone through receiving the report, 5 iterations. We acknowledged and accepted the 5th, and we went to virtual public meeting. We have had responses from members of the public, and we have some outstanding government ministries, departments, and agencies to respond. So as PS Suel said, the process continues, but we are not at the point of making a decision.
The other question I had for you is, how many responses? You had a virtual consultation. How many responses? And I should ask you, Mr. Knight, when do you think you will conclude the process to come to a decision? And let me just put this in there. What's absent for me in your deliberations, and it's not clear. I see what JNHT has said, etc. But the social cost to residents, apart from the dust and etc., what are some of the responses and how many are coming forward? And then, depending on what you answer there, I'll ask a follow-up question.
Member, I didn't count the number of responses, but I can answer you this way. We have received a number of comments from academia, members of academia, from environmental NGOs, environmental non-government organizations, from other academics, and from residents. A number of responses. We have collated all of those responses because sometimes you will find that a stakeholder may ask a similar question or the exact question. So we would have collated all of those questions, concerns, query of the science, of the evidence, and we would have made those available to the consultants for them to respond. I would say, your other question, I would say we have another at least 2 months before we would be in a position to complete all the review and the receiving the responses from the consultants that we can do, go forward with a decision. The social costs, the environmental impact assessment report would have pointed those out and the mitigation measures. We're not in a position to speak definitively.
Mr. Knight, hold on 1 second. The reason why I raise them is because for years I've been coming to listen to NEPA and others speak about the impact of bauxite and bauxite mining, particularly in communities. As I think there are about 1, 2, 3, 4 of us here who are directly impacted by bauxite mining, both in terms of the land use, in terms of the dust, in terms of just a number of areas, because we never see the management contracts between the bauxite companies and the government and other entities. And the reason why I raise it is because every time we speak about the social costs, whether it is in the impact assessment or otherwise, you always have the same answers, and then there is no real follow-through. And so the impact on my health centers, for instance, every time the residents in my area say that the dust is affecting their sinuses and they're sick, but I don't know that there's anything really to address it. So why I ask about it is that if you're concluding in 2 months, what real justification and what kind of surety will I have as a member of this committee that you will follow through depending on the decision that you will take? Because are you going to come in 2 months with the decision, or are you going to continue to highlight the nation as to what your decision could possibly be?
Fair question, member. So my response is, and I hope I wasn't giving the impression that there are no impacts. Of course, there are impacts. But I can also say that over the past 8 years, there have been improvements in the monitoring and enforcement of the sector. And we have had positive responses from the industry based on the interventions and enforcement measures we have put in place. If you review complaints and demonstrations and pollution incidents over the past couple of years, you would have seen that there is a fall in those incidences. So our monitoring and enforcement programs have been escalated. The intervention with the bauxite sector, we have regular quarterly meeting with industry to discuss issues. But we still know that there are still impacts that we have to be mindful of. So the purpose of now considering this application and the review of the environmental impact assessment and the air dispersion model that accompanies those our scientists have to pay special attention to how these models, how these mitigation measures are going to be conditioned in the permit to reduce the impacts on residents and the environment. So the environmental permits, not sure if you are familiar with how the permitting works, but what we do is we stipulate both general and specific conditions that industry must comply with, which also includes a reporting mechanism. They have also to self-report in a number of areas.
Good morning,
Go ahead,
team.
member.
Mr. Knight, morning to you. I just wanted to find out whether or not there has been a response, if any, from the WRA in relation to the effects or possible effects to our water systems. Because, for example, because we have a turbidity problem in some areas in Trelawney, and we don't know whether or not there is a correlation. So has there been anything yet?
Yes, we have had responses from the Water Resources Authority. We had responses on the preliminary reports, and we have had responses on the final report, and we have had responses on the public consultation. We have detailed analyses, critique, if you may, from the Water Resources Authority. They have given us pages of comments with a number of images with wells and so on that we have onward sent to the consultants, because those are critical questions and concerns and the science and the evidence that have to be answered before we can go forward. So 2 months may even be too short, because it depends on how the consultant handles the response. And the WRA has to be satisfied that what the consultant, the science that they are bringing and the evidence, that they are going to support those conclusions.
Go ahead, member.
One of the things that you actually said in the report is that there is a limestone aquifer That's about 100 meters down. And that one of the things that you were going to do is to make sure that the company does not mine below 10 meters. I don't know how you measure that. I mean, how are you going to ensure that that is, how do you stop it? Suppose they go to 11 meters or 15 meters. And at what point in the WRA assessment that you will see, do they say that you can't go below a certain amount? Because I don't know how you would really monitor. Maybe you can, and that's something that you probably need to share with us.
Yes, member, but remember what P.S. Sewell said, and it's in that first paragraph in introduction. It is way too early to have those sort of conclusions, whether how mining will be done, if it will be allowed. No, it's way too early.
Mr. Knight, with respect, it's not the first time we're doing bauxite mining in Jamaica, correct? Yeah, I think all of us are aware of that. You said yourself that this process has started since 2018. So there must be some degree of in your own consciousness as well, as to how you feel this is all going to proceed, because they have a deal to do mining for 30 years, 25 years. So if you do this particular license and this becomes precedent, then what happens? They can go into the other areas, even though that it says in the report that they are not gauged for mining per se. So I don't take the point that it's too early to tell me information on that particular area.
Remember, yes, it's too early. And remember, we can't, and I don't mean any disrespect, we can't go by feelings. We have to go by the science, and we have to go by the evidence that is before us. We have to allow the process to work. As I said, there are fundamental questions that have been asked by members of academia from some of the universities and so on. There are fundamental questions. There are science, evidence-based questions that have to be responded to satisfactorily by the consultants. So, and the process is, remember, let's suppose the consultant comes back with responses. Remember that we have to now go back to, let's say it's faculty of whatever at the university. We have to make the responses available. Are you satisfied that this is responding? And you are satisfied that the process that is now outlined. So even saying 2 months, the process can take longer because as the agency, and we have strict instructions from the cabinet, we can't go ahead and make decisions unless we are satisfied with the science and with the evidence.
But can I just have follow up on that before you go? But Mr. Knight, if it is then that academia and other groupings have done their research, and this area that is now a part of the special mining license 173 that is being proposed, and that the WRA has concerns because of aquifer, limestones, geological interest, forestry, then wouldn't in this case, seeing that the proposed boundary or the approved boundary for the protected cockpit country, wouldn't your organization then do its own environmental impact assessment to see if that area should then fall within the protected area before another entity just like Noranda applying for a mining license? Why not then your agency then, seeing that you are in that process of approving the boundaries of the protected area for the cockpit country, then not do your own assessment of that area, since that area itself, as in your words, have been the concern of other interested parties?
Chairman, I can respond to say that the boundary that the government of Jamaica decided on for the cockpit country protected areas, all of us as government regulatory agencies, we own that. because we were the one who advised the government. All of us as government regulator, we were all involved in the process. The government listened to all the positions, and that area that is defined as the cockpit country protected area, all of us own it. The WRA, NEPA, Forestry Department, we all own it. So none of us can come out and say that this was a unilateral decision by the government. No, I want to answer the follow-up. So the boundary that was determined, we all agreed that areas outside of what is defined as the cockpit country protected could be examined subject to an environmental impact assessment report, which is the decision-making tool. So if the EIA, and remember, Chairman, I said, remember, the terms of reference, we are not going to go and do an independent EIA. We have given a terms of reference, which we have made available to you, with strong science-based, research-based questions to be answered that can make us, all of us as regulatory agencies, comfortable with whatever decision we are going to make going forward. I don't know if that answers your question.
Well, how far back did the exploration of mining within the cockpit area, how far back did that start?
In the question, when you say how far back, because no mining is taking place now.
Yeah, but there was some exploration. Wouldn't have there been some exploration to see if there is bauxite there or not? Or
well, perhaps, Chairman, we could refer to the map that is on the board. Mm-hmm. So you notice that there is an area that's in green and also in yellow. And that's in St. Anne. Mm-hmm. So that line that comes on that marks the border between St. Anne and Trelawney. That area, the area in yellow and in green, are areas that have been already licensed for mining. Mm-hmm. Right? So the area of SML 173 straddles both St. Anne and Trelawney. So in reference to the question that was raised by a member, Novo, the mining has not yet taken place in Trelawney. We have no experience or knowledge of a mining taking place in the parish of Trelawney. Mining has always been in St. Anne. Now, in terms of the boundary, I'd like us to recall that the basis for coming up with the cockpit country protected area was on the basis and on the information, the scientific information relating to the forest cover, the biodiversity, the water resources, and as the CEO mentioned, and the heritage information. On that basis, the demarcation was made.
But let me ask you, for a bauxite entity to go into an area to do testing, do they have to get a permit from NEPA?
Yes, Chairman. Since we amended the regulations in 2015, that is now a requirement.
So before they didn't need?
No, because...
So in a sense, that's what I'm really asking.
Yes.
Because to go into an area to see if there's bauxite, because we know that bauxite companies don't just go inside there and just dig up a few feet and then say, boy, there is enough quantities there. So that's why I was asking about the exploration within the cockpit area. From how far back do we have any knowledge of the bauxite companies going in there, testing to see if there is adequate bauxite inside there?
Chairman, that would have been, as our member said earlier, that would have been going on for years since the bauxite industry is operational.
And wouldn't the NEPA have some control, even though it wasn't a requirement, but have some knowledge of it and things?
Yeah, remember...
And I'm speaking specifically now about the cockpit.
No, man, I follow you. Good. The NRC Act is 1991. So before that, it was left to MGD and JBI Jamaica Bauxite Institute to determine, since the NRC Act that requires permitting and licensing, we have corrected that, and since 2015, we amended the permits and license regulations to include all entities that existed prior to, because there was a grandfather clause that said if you existed before, you didn't require environmental permit. But we corrected that, a policy decision again, that was corrected in 2015 to make it mandatory that if you're operating an enterprise, you require environmental permit.
The Copic Country Stakeholders Group, which did a report, did this proposed area for the SML 173, did it fall within that proposed boundary that was recommended in that report?
I'm hazy on that, and probably Ms. Guthrie could answer that question.
Yes, thank you, Chairman. When the government deliberated on the proposed boundary of the Copic Country Protected Area, there were several scenarios that were presented, and including one from the Copic Country Stakeholders Group. And so all of these scenarios, and even some from academia, so all of these scenarios were examined based on the 4 criteria that Mr. Knight had indicated in terms of the ecology of the area, cultural and heritage sites, the water resources, etc. So all of that was evaluated, and also the geology and the geomorphology of the area, because remember now that the Copic Country has a specific feature. So all of that was taken into account. All these scenarios were taken into account and aligned with the criteria. And the boundary that the Prime Minister announced was the boundary that we was decided on as the most appropriate one. So it's not the Copic Country Stakeholder Group's boundary, but it is a boundary that takes into account the 4 criteria that I had articulated prior.
Thank you. Member.
Thank you, Mr. Chairman. In accordance to the NRCA of 1991, Noranda is asked, or is required, to do an EIA. How far is that? Because I'm very concerned about there's something that needs to be done. But the one that is more important in my mind is the rehabilitation of the mined out lands. And that's what I really want to get to know, that we have something that we really can hold them to. So I want to ask the question of Mr. Knight. How far away are they with that report?
Remember we said earlier that we have now accepted the environmental impact assessment report of SML 173. There's a process. It goes from application. So we have a request for application to mine in this area. We would have done the screening, and we would have determined that this project requires an environmental impact assessment report. We would have developed terms of reference, and we would have issued those terms of reference. So the next step in the process would be for the consultants engaged by Noranda to go out and do the research based on the terms of reference and build the environmental impact assessment report. When that is done and the consultants are satisfied that they met the terms of reference, they would have submitted the draft EIA report. And as I said, it took us 5 iterations to accept it. In other words, when we did our internal review and with the government regulatory other partner agencies, we would have found issues that were not dealt with or needed further work. And we would have said to the consultant, you're not ready yet, go back and do some work. So when all of that is completed, and we reached a point where we accepted the report, we would have posted it on the website, and we would have mandated consultation, public consultation. And that public consultation, the consultant would have done some consultation on the ground with the residents, going around and so on. But that is their consultation. The mandatory NRCA Government of Jamaica consultation is that it must go public, the widest public. Because of the COVID pandemic, we had to modify it to allow for a virtual consultation. And that virtual consultation was done in the 8th of December. And it was very well, I would say, attended. And this is a process where the consultant would present the report as to the findings and so on. NEPA would make an opening statement, the consultants would present. And then we allow 20 days after that for the public to respond. And that's why I made the point that we have these responses from academia, from environmental NGOs, from civil society members, from the ordinary man in the street. So we now have to go back. So there's another review now, apart from reviewing the EIA. We now have to go back now and review all of these comments that we are receiving, collate them, make them available to the consultant for them to answer these questions, to respond. So in a way, they are doing research for us as the environmental agency. When it comes to rehabilitation, that is not our mandate. That mandate belongs to the Mines and Geology Division. And I would prefer for them to speak to how that process works and what percentage of lands, mined-out lands, have been rehabilitated.
You know, Madam Pearson, Mr. Knight, because I somewhat am of the impression that in the instance of mining, yeah, that the mining entities are more protected and have more rights than us, the citizens. I tell you why I say that. Issue of how residents are treated when mining is taking place, in how it is that they operate within communities, meaning the mining entities. I have an issue in my own constituency where an entity has been given a permit to mine in the area, but yet still, when we ask about the haulage road, they can tell us, boy, it is 1 year away, 2 years away, but yet still they're using the public road without any recourse for any bushing or patching, because them says not the trucks that mashing up the road. But they're allowed to mine for an extended period of time without putting in adequate roads to divert them from the public roads. In how, even though it is said that the lands are owned by them, in just how farmers are treated when they have to come out of the lands. And believe me, but the mining itself causes poverty to those same people that has to be relocate or taken off of the lands. Yeah? So for me, it is an overall issue, and I speak about a community in Manchester called Blue Mountain, which I have roots to. And I remember the days as a little boy seeing the orange orchards and the pine and willow trees. And if you go to Blue Mountain now, and look at as if it was an atomic bomb that fell there. All it is dust and sinkholes. And within the community itself, why is it that we can't have a buffer between communities and the areas that can be mined? Sure.
Mr. Knight, what perhaps we should discuss, Mr. Chairman, at some point going forward, and I remember years ago, the Economic Production Committee of Parliament, we actually looked at the impact of bauxite in communities across the country. But perhaps we should look at what goes into the management contract before they are signed, and rather than put the cart behind the horse, or in front of the horse, I should say, because we keep coming back and having the same problems, because what happens is the communities suffer. So, for example, if a bauxite company is in a community, depending on how much equipment they have, just in following up from member Phillips's question, why is it that 5% of the time that that equipment is used in a community, why can't the community get it to do farming or cut another road, etc.? So those are some of the things that in discussing, when NEPA comes to and the agencies come and then start asking the residents after the fact, is putting the cart before the horse. The two questions I have to follow up as well is you say in the report that it's really not pristine lands. The lands were already disrupted by farming, so it means that farming is taking place, correct? What compensation would NEPA or the ministry consider giving, particularly to yam farmers who are there operating? And then what kind of dislocation is going to be caused? And then the other question I have for you, in terms of the ecotourism that is now taking place and the heritage sites that are there, because a number of heritage sites and graves, and every time people start digging, we start seeing some other things. What are the responses that you have been coming up so far to deal with the agricultural dislocation to farmers and then to deal with the heritage site issue? Do you have any responses from JNHT or from the technical personnel?
Yes. Okay, I heard the comment of the chairman, followed by the comment of Member Hannah in terms of some of the issues regarding the issuance of mining license. And I think that these are issues that require broader discussion because to issue a mining license, we don't have that remit, for example, in the Ministry of Economic Growth and Job Creation or HUREC or NEPA. Our remit is primarily the environmental permit. But I do understand, and I would suggest that possibly this discussion be elevated, because, Chairman, when I heard you address the PS directly, one would form the impression that it is something that I have direct responsibility for. So I'm going to suggest that these concerns be raised otherwise, and that seriously they be considered going forward.
But let me ask you though, Madam PS, through you to Mr. Knight also. For a bauxite company doing mining in a community, for them to mine that particular area, do they have to get a permit from NEPA to do the trucking from that area from point A to point B?
So let me respond. Two responses, and let me start with the latter. The environmental permit and the conditions would specify the conditions for trucking and how it is to be done. So trucks you are to operate Monday to Friday, for example, between 5 a.m. and 5 p.m. Trucks are to be covered, mufflers, silencers and mufflers, and no blowing of horns, those sort of things that would be in the environmental permit. And so if there is not compliance, then it would be a breach.
All right, so let me go back to Mile Gully then. Right? So mining is taking place in Mile Gully as it is now. For the last 4 years, there has been trucking of bauxite from there to Clarendon. In my meeting last year with the mining company, is that yes, a haulage road should be put in, but we can't tell you when. My meeting with them 2 weeks ago, boy, we're about a year off, but. And we were at pains with them when we first met, when they were starting back the haulage a year or two ago, that there can't be any haulage during the morning period when there's school in session because of how narrow the roads are. And we ensured that that was put in there. And after school, when school is out, if you know that Mile Gully Road, the narrowness of the road, that I don't know how longer, and why I bring it up is because they have been given that permit by NEPA to do haulage. So I would like to know how long then would it have to take, or what would have to happen for some stipulation that they have to put in a mining road when operating in communities like Mile Gully. How long then is it stipulated that they have to put in that alternate route to take the trucks off the public roads?
Chairman, I have to go back to what PS Sewell outlined. Those are not our mandate. Those are wider issues.
Yeah, but you issued a license for them to be able to transport?
No, we issued the environmental permit, and we would have given conditions for trucking.
So who is responsible then?
Remember, you have the JBI, Jamaica Bauxite Institute, you have the Mines and Geology Division, you have the NWA. So as PS rightly said, this need interagency discussion as to those are not our remit.
But wouldn't you give them the permit on the basis of other agencies?
For the environment and public health issues.
And they can't transport the bauxite without your permit. So is it that because NWA say yes, NEPA don't go out there to do their own assessment of if the road itself can accommodate these vehicles? Nothing? So you just take it from the other agency?
Get some advice on that, Chairman.
The problem, Mr. Chairman, I think the problem here is the policing. That is the problem.
No, my issue is not the policing, you know.
No, but that's a policing. I mean, there must be somebody which agency is in charge of ensuring that it happens.
Who tell them that they can go on the public road without having to look at an alternate route? And it's going to take them 5 years to look at the alternate route. When vehicles are passing those trucks on the Mile Gully Road, they have to go on the banking because the road cannot hold a truck and a car.
Yeah, but what Mr. Knight is saying is that they give the permission with conditions, right? But who is there to ensure that
remember,
the
with all due
conditions are
respect,
met?
but at least if it is that a mining road is required, a haulage road, then who then gives the time frame for them to be able to put in that haulage road that we no longer? Yeah, but he has to give the environmental permit for them to haul. Member
Frank Whittle. Because I was a little bit lost when I heard the response from Mr. Knight about this agency, that agency, and that agency. It just combobulating to the public. The persons who are affected by the activity that is licensed, permitted by the state, has no recourse on a one-stop basis that, you know, if you see a man shooting somebody, you call the police, you know where to go. Where do you go when John Public sees this offense taking place? Mr. Knight, name about 3 different agencies. Yeah, and so the person will run all over the place. And that's almost the norm. That's why people are so frustrated and feel hopeless. You must be able to say, if this offending action is taking place, even NEPA, then take charge and direct it to Whereview. You are the environmental entity. A member of the public says there's an seeming offense taking place here. You send an officer to verify whether or not the complaint is valid, and then take it from there. That person's journey stops because he has reported it to the state, the government.
Chairman, I think we have to give some clarification because we're mixing apples and grapes. The National Environment and Planning Agency, as an agent for the Natural Resources Conservation Authority, we don't issue license. we issue an environmental permit if the facility meet the requirements. Let me just finish. Licenses are issued by the Mines and Geology Division. They, under the Mining Act, they are the ones that issue mining licenses. But they can't issue a mining license unless there's an environmental permit, which is a precursor. So, and then the Jamaica Bauxite Institute also has a regulatory function for the bauxite industry. So we have to make it clear that we can't accept the other agencies' mandate and responsibility.
All right.
And as P.S. Sewell said, what it requires is a larger discussion as to how we coordinate and look at all of those
All
issues.
right, direct me then. Who gives them permission to drive these trucks, even though licensed to drive for an extended period of time while mining on the public's road? Who? Which agency?
Chairman, I would suggest that you would have to bring before you MGD, JBI, NWA, and the Ministry of Transport and Mining for them to answer those questions. We can't answer that question. But I'd also like to answer Member Hannah's question about heritage sites.
Well, I will say before you answer that, again, it is the public that gets shafted by responses like that, because, you know, I'm sure when we bring all of them together, nobody's going to claim that it is they who. But again, I raise a point: who protects the public in this case and other cases like it? Because when mining in a community and an area, as Member Witter would have more experience than most of us here, even them don't demonstrate, them get no response. And it is sad, because what we get back coming out of the out of the bauxite levy to put back into communities is a crying shame that as governments, successive governments, what is put back, and God bless what even with all the PR that the bauxite companies claim they put back in communities, cannot compensate for the damages and upheaval of families and households and loss to agriculture. It is a crying shame.
So Chairman, Member Hannah did ask a question about heritage sites, and probably I was...
Just before you proceed, I don't feel comfortable with leaving this subject, and I think it's more directed at, my comment is more directed at the PS, right? I understand clearly what Mr. Knight has set out about the role of the different agencies, but since most of those agencies fall under the ministry, can the ministry undertake?
Which ministry, sir?
It is all over.
NEPA falls under the Ministry of Economic Growth and Job Creation. I don't have any other mining-related agency under my portfolio.
Maybe my pointing out to you, PS, is because I think you have the reach to pull these things together so that a one entity can play that lead role.
And I'll smile at that.
And which other agency falls under the Ministry of Environment that has to do with these minings? Any? Okay. Because if NEPA falls under Ministry of Economic Growth, with Ministry of Environment, what agencies fall under Ministry of Environment? Can you say, Madam PS? Nothing? So what are the Ministry of?
The environment portfolio is with HUREC, and the focus there is on policy. A decision has been taken for now to keep NEPA with planning, because most people believe that NEPA does only environmental permits and so, but NEPA is the National Planning Agency, and we have a National Planning Branch in the Ministry of Economic Growth and Job Creation. And one of the concerns is the time frames in processing plans and getting things to move across seamlessly. And so, for now, the Prime Minister took the decision to keep both together to see how they can improve the turnaround times in that regard. A lot of emphasis is not being put on NEPA's role as planner. And so the new ministry will focus on environmental policies, and they have a whole lot. If you were to ask me, Gillian is here, she can elaborate on that area. And he did say, for now, because there is a project to get the planning function going and going more efficiently.
Can I ask a question, Madam Pearson, Mr. Knight? When an application is made by a developer, a mining entity, before approval, is that uploaded, that application uploaded to your website? That the general public can see and make comments if needs be? Or is it uploaded after the approval?
All applications, you mean all applications? Or
yes,
those that
all
require?
Applications.
Well, all applications are on a software that we call Amanda. And if you know the reference number, you can input that reference number and you can see the process.
So the general public can go on the Amanda system?
Can go and can see where the process is.
Okay. Right.
Chairman, you see, we come here and we raise these issues, and they're obvious concern to every member here. I think we must leave here with a sense of where we go from here. I hear the PS just mentioned about the planning function in the ministry. The planning cannot be only for facilitating the execution of project. It must be also about protecting the public's interests. Much of what was voiced
and
here,
that's,
well,
yes.
1 second, please. Much of what have been voiced here. So in that planning role of NEPA in the ministry, there must be either a parallel connecting entity that ensure that whatever decision is made by any of those agencies, the environmental protection, the issues which we raise here, they are dealt with almost hand in hand with those approval that goes. Because I'm going to leave here this morning and we hear all that you spoke about, Chairman, and having no sense of how it is going to resolve or anything of that nature that should arise again. How is it dealt with? We must be solutions oriented.
I agree with you, sir. And whatever is within our remit, we will ensure that there is follow-up, as we usually do. And so if I too get a clearer understanding of what is being asked of us, we can make the commitment that any follow-up that is required will be done. Probably we too are not sure what is being asked, and this is why we have answered the way we have, because we are being asked to follow up and do things that are really not directly under our portfolio.
Well, Madam Pierce, I keep on when it is convenient here, the whole that about join up government. And at this point, I feel that it is more disjointed than join up. But be it that it's me. Members, anybody else?
Yes, Chair. Just a comment.
Oh, sure.
Just a comment here. This is calling us to look at the agencies, the ministries, the departments, even the very parliament where we operate, to see how we go about effectively serving the public and how efficient our means of communication is. So I quite take the point, right? I accept the point that NEPA is here to report on maybe the matters concerning its remit. And all I think we should insist on is that there may be greater levels of communication, greater partnership. We move towards not operating as silos, you know, we are more now focused on public education, because I think that is needed. There are so many of our people who don't have any idea as to where to go for what. Indeed, Chairman, I spoke to someone the other day and I said that, hold on, you mean that you have individuals at a particular place still collecting benefit in the names of persons who are dead? And I said, why is this happening? So doesn't the ministry have any kind of communication with the RGD? Maybe these pieces of information could be uploaded, you know, so that we can be more efficient. So coming out of this discussion, we can think about how effective we can be. And on the issue, I just want to add, Chair, that the interest of most Jamaicans is to ensure that the environment is protected. And they do not want to see us here appearing as if we are shifting or hiding something. They want to see that we are on the same page, ensuring that while we grow, we build, we develop, we protect our environment. Thank you.
Member Whittle.
Mr. Chair, it's my understanding that the local planning authority really is the municipal corporations, and they are the ones who really have the final say in terms of planning. I remember some time ago, while I was chairman of the St. Elizabeth Parish Council, there used to be an officer who, from NEPA, who attends the meeting of the local authority every month. Is this still taking place? Do you have your parish officers who attend these meetings?
Yes, member. The municipal corporations have what they call Planning and Development Committee, and those are attended. And they also have what I call enforcement, and I can't remember the name. But yes, it's kind of joined up the government agencies at that level to discuss the issues and to look for solutions. Member who spoke about the partnership and communication, we have a prime example of what you spoke of, and it is a subcommittee of the NRCA, TCPA, Natural Resources Conservation Authority, Town and Country Planning Authority. It's called a Technical Review Committee, and this Technical Review Committee has membership right across government. And you may say that some of them, what are they doing? But we have JAMPRO, we have the local government and rural development, we have JBI, Mines and Geology, NWA, Water Resources Authority, right across NWC. So all of these applications that are being considered, when all of the considerations are completed and so on, it goes before this technical review committee, and all the agencies of government all have this opportunity of digging further, asking questions on where we are.
There's a follow-up, and this is for the PS. This is for the PS. Some time ago, there was the idea of join-up government where you would have a one-stop shop for all development and so on. Where are we with that? The one-stop shop that was being proposed.
Rollins, you may want to talk, but it is work in progress. And as Mr. Knight has said, there is a technical working committee. Some aspects are currently being piloted, and I think much effort has been made, and Rollins, you probably would want to elaborate on that.
Good morning, members and chair. The one-stop shop was conceived a few years ago, well, quite a number of years ago, and as PS mentioned, it's still work in progress. But the Development Assistance Center at NEPA is the first stage of the one-stop shop. So if a developer has an application, the DAC is available for consultation, that the developer can come and present the application, and they can receive guidance on the procedure, the standard, etc., in order to undertake that type of development. So it's still work in progress.
Chair, as a newbie, Chair,
go ahead.
Mr. Knight made reference to the IRC, TRC, the Technical Internal Review Committees. I would imagine that from those discussions, you would have had comprehensive, in-depth review of anything before that committee, which means all the issues that we would have discussed today would have been captured somehow. From that, I would imagine that conditions would be drafted based on those issues. What I want to know is, where are those conditions captured in the issuing of permits/licenses? Is it that only what affects NEPA is included in NEPA's permit, and what affects anything else, where is that included? Because it is the basis of those conditions being included within whatever permit or licenses that would dictate or determine how the operations then are carried out by the permittee. And then it is on that basis too that if there is a breach, then there can be recourse. So where are those conditions captured within the permits and licenses?
That's a very good question, member. And the environmental permit, by the very nature of how the process works, meaning that you bring together all the critical partners of government for consideration. So there are issues that if we don't get a response and a sign-off from the Ministry of Health, we're not going to move forward. So the involvement of ministries, department, and agency, critical to the process. What we do now is to take all of those recommendations, and sometimes the agency don't specify a condition. We have to take it and make them into conditions. Do all those conditions. So if you look at an environmental permit issued by the NRC and NEPA, you will see conditions in there from all of these critical agencies. And how the process works after that, go back to the member who spoke about communication and partnership, is that sometimes we have joint monitoring framework on the ground. So the NWA may have specified conditions for drainage and setback and ingress, egress, and so on. When we go to follow up on these conditions of the permit, those are checked. We also have some permits that are classified as special SML, special monitoring. So those, because of the nature of the approval and the nature of the environment and issues for public health, those are given a special monitoring regime.
But to follow up then, Mr. Knight, so the conditions, as you say, would capture some of the other entities that would have concerns, and it is placed in your permit. But so when there is a breach then, how is it treated if that particular condition does not rest with your environmental portfolio?
And exactly what I'm saying. So let's say that we issue a permit for that has to do with quarrying, and there are breaches of the conditions that are specified by MGD. Remember that the joint monitoring on the ground would have picked that up. So we would have cited, because the permit belongs to the NRC and NEPA, but we would have engaged the MGD to work with us to correct or for the interventions to deal with the breaches of those conditions.
Chair.
Mr. Knight, I think what most people, most Jamaicans, and I heard Member Jackson and member from North Trelawney related to it, the areas that we are, this company already has a special mining lease, correct? Noranda already has a special mining lease to operate within certain lands of that area. The specific one that's in focus, 173, is the land that's closest to the protected area. So is it that they can proceed in the other 5 areas? They have, the lease consists of 6 lots. One of the lots is the one that we are concerned with. So my question is, until this is decided, are they able to mine in the other areas?
Yes, member, because those other areas would have gone through the process and would have been cleared already. So Noranda, for example, is now working on the ground, I think, in SPL. So Richard is pointing out. So the company would have gone through a process and obtained approval for some of these areas.
So the question I'm asking primarily, when they were granted the special mining lease for this particular area and the approvals given, was the approval also, because it would appear that the approval was given for all 6 areas, how is it that this one has really just come up and has become such a source of concern?
Remember, the bauxite companies tend to phase how they do their mining and their strategic plan, which areas they're going to move to next. As they plan on the areas, they first get the pre-clearance, meaning that you would have satisfied the conditions for the environmental permit.
All right, forgive me, because I'm not as technical as you are. What I'm asking is when the lease, because a special mining lease, right, that they were granted, was that mining lease incorporating all of the particular areas, the 6 areas? So when the special lease was granted, did they have approval to mine in those areas? Because it appears that it wasn't until the government gave the protection to the other areas in 2017, I believe, Ms. Hamilton, correct me if I'm wrong, 2020, that this became an issue. If the government never gave the protection, they could have just continued mining.
Remember, which is what I thought I explained earlier. Let me just go again. When the boundary for the cockpit country protected area, when that specific boundary was considered, the cabinet took a decision that as we go forward in that area, must benefit from an environmental impact assessment as a decision-making tool. So there would have been other areas that would have been benefited from EIA and would have been cleared already. So I don't know which 6 areas, but the SML 173 is not yet cleared.
Mr. Knight, the particular areas that were already cleared, so do you have to get clearance to get a special mining license?
Yes, you have to get the environmental permit to get the special mining license.
So what I'm saying is, Noranda would have gotten that special permit even for 173 before. It was not until the government protected it that they now had to come back to you, to NEPA. So the question that Ms. Hamilton was asking before, about the permits and how permits are granted, how is it that if this was in the cockpit country or near to it, that even before the special license was granted, that never NEPA or other forestry or anybody never jump up and say, hang on a minute, do you understand the fundamental question I'm asking? In other words, the special lease that was granted originally had not the government protected the area, which one of the places fell into that property, they could have proceeded to mine that area. Just now, because it has been protected, why we are coming to all of this. That's the question I'm trying to get to the bottom of. So in other words, all of us are sitting here saying, but had this not been protected, it would be mining, we wouldn't be having this discussion. And so at what point does NEPA and forestry and everybody jump up and say, hang on a minute, even before the special license was granted, you can't mine in this area, so don't put that part of the property in the special mining lease.
Member, I answered that earlier, so let me go again. Remember, I said that a number of entities.
It's just a yes or no question, though, you know, Mr.
No,
Knight.
but I have to explain. A number of entities and processes were exempted from permits and licensing prior to 2015, when we amended the regulations to make it mandatory that you must receive an environmental permit to undertake specific activities. So prior to 2015, the bauxite companies could have moved into an area, commenced mining could have moved into an area, receive a license, and commence operation without any environmental clearance. And that is why, policy-wise, we corrected that. So going forward since 2015, you must receive environmental clearance before you can commence activity and a license. Now, in when the cabinet and the prime minister announced the cockpit country protected area, it was re-emphasized that in those areas, although it existed for other areas too, there must be this requirement, the mandatory requirement for an environmental impact assessment report. So we have 3 companies now. UC Russell, who is doing an environmental permit in an area adjacent to Sentan area. We have Gisco Alpart, who is doing an environmental impact assessment report for a swath of land in that area. And we have this SML 173, where the EIA was completed, accepted, and is going through the process. So I don't know if that helps.
I have Member Morrison and Member Wright. Okay. Member Wright. And then Member Jackson.
Thank you very much, Chairman. I'm just checking. When was the license granted? Because hearing now that all 5 areas was granted, is it a case where the license was granted and after revision, they noticed that this area in question was merely in breach or take into consideration of unminded areas? So just need some clarity on that.
So member, it's kind of difficult to answer because I don't know which 5 areas. Honestly, I don't know which are the 5 areas.
173? No. Right. So 172.
Yeah, I think the question he's asking, when was the license granted for the other areas under special mining license?
Right, Chairman, and that's what I'm explaining, that we don't issue licenses.
Or when was the environmental permit issued for the other areas?
Yes, I would suggest that what we would have to do, we would have to look at those areas and we would have to prepare that report to submit to the committee, because I don't want to say to the committee and the information is incorrect. So we would have to look at the areas and look when permits were issued, and we could make that information available.
Okay, well,
to the committee.
We'll have that request through the PS. No, well, we're asking about the environmental permits. We understand that, so that's why I corrected it, Madam. Yes, yes. Madam Davis, Member Davis.
The question really was along the same lines, since an environmental permit would have been granted already in this area. The question really was, what is causing the difference in SML 173? So I think this is what you just answered when you said you'd have to find out what caused the permits to be granted earlier and see if there's any difference. Is that what you're saying?
Yes, and what caused the difference since 2015 is that we amended the legislative permit and licenses regulation, the NRCA permits and license regulation, and that makes it mandatory for an environmental permit. It is when we do the screening of the application that we determine whether an EIA is going to be mandatory or we are going to do an assessment. So that's what I was trying to explain.
Yeah, we get that.
Member Jackson.
Mr. Chair.
Sorry, hold 1 second. Yes, Mr.
Just to add, in general, I think we're speaking about two separate but related issues. The leases are granted for mining, but those leases will be subject to you receiving an environmental permit with conditions in order to enable you to do the mining.
Okay, all right. Thanks for the explanation. Thank you, sir.
Clarification. Mr. Knight, you all mentioned about the 3 other companies, UC, Russell, Gisco, and another, that were conducting EIAs at this time. Those are not within the protective areas.
Not at all, member.
Okay.
Is in St. Elizabeth and one is in St. Catherine.
Yeah. All right, so you will send that information to the clerk of the committee.
We will, Chairman.
Yes. Mr. Knight, the last time you were here, we spoke of the bond that should have been paid by Bengal. And that we have seen in the media where there has been an extension for the payment of that bond. Can you give us the reason on why Bengal was seeking an extension?
Chairman, we receive a request from Bengal Development Limited for an extension in the time that it would be required to pay the bond. That matter was considered by the NRCA TCPA. I don't have at hand now the arguments that Bengal would have placed before the authority, but I'm sure it would have been related to the other processes that we are not responsible for, which is the mining licenses and so on. So they could have made, they may have made an argument about, because remember, you have the permit now, but you have to get the license. And I don't recall, I'm hazy in my head what was said, but it was considered, and the 60 days was allowed.
Let me ask you, are you a part of the decision that NRCA would have made?
I was a part of
right,
it.
So, all right, on what basis then NRCA then give the permission for an extension then?
And I'm saying it would be in response to the request from the permittee. for an extension. And remember, Chairman, I'm not denying that I know what I'm saying. I don't have in my head what the reasons were for the request.
Well, I find that a little bit surprising. It's better you tell me you don't want to tell me. But to say that you don't remember an issue like this that has been in the public's view for quite a while, that you're coming to the committee to say you don't know the issues when you were a part of the process, and I'm sure if you voted or did not voted for the extension, but I would expect that you could give me an outline of why then did the NRCA grant it to Bengal the extension? On what basis?
Chairman, I recall that when we came to this committee about that matter, the PS had outlined to the committee, and the committee went in caucus and discussed that this matter is sub judice, and we don't want to discuss the details of this matter.
No, but you know, with all due respect, Mr. Knight and Madam Permanent Secretary, you came to the committee the last time, and when the question was asked about that, about what would be the conditions of the extension, you gladly answered, even after saying that it is sub judice. And I'm just asking in the public's interest at this point in time, I don't say how this will affect the matter in court, for you to be able to say, why is it then that NEPA? Because you are at ease in saying that the process is not stalled because there's a matter in court, but it continues. And while that is so, NRCA has gone ahead and granted an extension to a bond that should have been paid on the 17th, and granted an extension for a period of time. And all we're asking it is, on what basis has that extension been granted?
Chairman, we would have to be advised, and as honestly, I don't have, because we did not come to, so I would have pulled the file, I would have brought correspondences and decisions with us. I didn't know that that matter would come up. What I can tell you is that there was a request for an extension in the payment of the bond. The matter was considered. The requests, the days that were requested were not supported. It was reduced to 60 days. But we would have to be advised now if we can send to the committee.
Amazing that you remember the days, but you can't remember the reason why. But be it that it may.
Chair, may I make a comment? Chair, could I recommend that Mr. Knight and the PS just get some information, and based on information or advice that you get, you can determine what you can send to us at a later stage.
Thank you, member. That's what I was going to ask. I am not a lawyer. I take advice from the Attorney General's chambers. And when I came the last time on that matter, the advice was that we should not discuss the matter publicly because it's sub judice. If additional questions are being asked, I would like to consult with the AG's chambers to determine whether this particular question we may send the response. We are not here skirting around anything, Chairman, and the person should know I've always tried to be open and to be transparent. And if a matter is before the court and we are advised by the AG chambers how to approach it, if we are asked additional questions, I would be willing to send information immediately if I am advised by the chambers that it's okay to, because they are representing the government in this regard.
Can the Permanent Secretary say if a lawsuit has been filed for re-SML 173?
I am not aware. That has not been brought to my attention.
My information is that one was filed on January 20th.
Well, we have
the
not.
Attorney General.
We have not received. Well, the ministry has not received any such documentation.
Can the Permanent Secretary clarify if that is so and then let us know at the committee?
Well, I suppose if I will ask the chambers or wherever, because I don't know who to go ask. I don't know where to ask for that information.
The Attorney General's Department.
Yeah,
just as you were advised.
But Chair, also in a situation like that where a lawsuit has been filed, I would imagine that NEPA would have to be served. And so prior to their service, they would really have no knowledge of it.
Well, it's information that in my research that I gathered. So that's why I'm asking the permanent secretary.
Generally, though, Chair, generally,
members,
when matters are filed against the government, the Attorney General's chambers is normally,
yes,
there's a party,
which I understand.
Which is why they would be served separately from.
Which I do understand, member. Okay. Thank you. Members, is there any other question? Members, are there any other questions? If not, let me thank the permanent secretary and the team from the ministry and from NEPA in being able to appear in front of the committee today and for the information given. Thank you. Members, we move to item 6. Is there any other business? Members, just on a matter of information, we had asked for reports from various MDAs to do with the economic recovery. When we were supposed to be, I think it's our next meeting, we should have had, we should have had some agencies appearing in front of the committee. Members? Member, clerk, I'm addressing a matter. We were supposed to get reports from some of these MDAs today. I think it is 2 have asked us for for an extension to be able to send the reports. So they're asking us to defer the sitting that should take place next week. Is that so? Right. To a later date. So we have asked them to see how quickly they can send those reports, and then what we will do is round robin by email to set a date for that meeting.
Effectively, Chair, you're saying we have no meeting next week?
Right. Because we would have to give, if it is that we're going to bring any other agency or department, we would at least have to give them 2 weeks' notice. So this would not be enough time. So most likely we'll not have a meeting next week. Members, I remember at one of the meetings I'd made a proposal as part of that whole economic recovery that we invite the JUTC to look at its viability and the effects of the COVID on the operations of the JUTC. So I'm asking members if we can go ahead after the meeting that we are going to reschedule, that we bring them once it is that we don't have the budget and everything in that will.
Just for clarification, Chair, is it the ultimate tire or urban transit?
Both.
Oh.
Both. Yes. See, your memory is quite good that you remember. All right, so I'm asking for the approval of the committee to also ask them for a report. And if there are any particular questions that any members would want within the report, that you passed on to the clerk of the committee. All right? Members, thank you. And Madam Clerk, I'm sure you'll send the required information to NEPA for the questions that were asked by the committee. And we will then round robin on the date of the next meeting as soon as we get those reports. All right, members, meeting adjourned.
Healthcare workers are working very hard to ensure lives are saved and people recover quickly from COVID-19. But their work is becoming harder because you're not wearing your mask, washing your hands with soap and water, or using hand sanitizer, and you are not maintaining physical distance. Let's limit the need for hospital beds and ventilators. Do the right thing. Cover your nose and mouth with a mask. Practice good hand hygiene and maintain a physical distance of 6 feet between you and others. COVID-19 is not over. Protect yourself while protecting others. A message from the Ministry of Health and Wellness.